Hello. Ready?
Sir, shall we start?
Ma'am, 1 minute, ma'am.
Yes, sir.
Monopriya? Monopriya?
Yes, sir.
Sir, this is Arul sir. Shall we start the session, sir? Sir? I have joined, sir. Thank you.
So shall we start, sir?
Yes.
A pleasant morning to one and all gathered here. It's my pleasure to welcome you all. I now call upon S. Priyadarshini to welcome the gathering.
A wonderful morning to everyone. A wonderful morning to one and all gather here on this marvelous day. We are gathered here for World Intellectual Property Day, holds a webinar on incense to intellectual property rights organized by Power Engineering College. I wholeheartedly welcome Dr. G. Balaji sir, head
A wonderful morning to one and all gathered here. On this marvelous day, we are gathered here for the World Intellectual Property Day, holds a webinar on rights to intellectual property rights organized by Power Engineering College. I am very grateful to welcome our principal, Dr. M. Premkumar sir, to the gathering. I wholeheartedly welcome Dr. G. Balaji sir, Head of Electrical and Electronics Engineering, Power Engineering College. Welcome you, sir. I extremely welcome Dr. Indumati, Associate Professor of Savita Engineering College, Chennai. Welcome you, ma'am. I extend my warm welcome to all our cherished faculty members and students of Power Engineering College. Welcome you all. On behalf of our department, once again, I welcome you all for this grateful webinar. Thank you.
Thank you, sister. Your positive action combined with positive thinking result in success. Now, our respected principal, Dr. M. Premkumar sir, to deliver his valuable words.
Thank you. Most respected guest speaker of the day. Am I audible?
Yes, sir.
Okay, thank you. Most respected
Yes,
guest
sir.
speaker of the day, Dr. Indumati, Associate Professor from Savita Engineering College. Respected Head of the Department, Vice President Dr. Sundaramurthy, Convener Dr. Mohanapriya, faculty members, and my dear students. So today we are organizing through Institution Innovation Council the Intellectual Property Day. So I'm very happy that the Department of Electrical and Electronics Engineering, they are conducting this webinar. And students, you know well that the importance of creating an intellectual property, because it gains the value of any country. Okay. In olden days, our system, it had a lot many laurels, but our ancient people, they failed to record or to get rights, and they failed to reserve that. So that is why many things have not been warned by or claimed by our country. So this webinar will help you to how to get the intellectual property things. And definitely, you know well that we have published many patents. Our students also, they have published many patents, and in the same way, it has to be taken to the next level. So kindly attend this program and interact with the guest speaker. I congratulate all the organizers and I wish you all the best. Thank you.
Thank you, sir. Thank you, sir, for being an inspirational one. No one can shake you or break you if you have the will to do something. Now, I call upon M. Nia to introduce our chief guest.
I'm profusely overjoyed to welcome our chief guest of the day, Dr. K. Indumati. Dr. K. Indumati is working as an associate professor EC in Savitha Engineering College, Chennai. She has finished her UG, PG, and doctorate degree in the Department of ECE in Anna University, PG DIPR in IG and OU, and currently doing her postdoctoral research in Chennai University of Taiwan. She holds the position of Conveyor IIC Coordinator, NISP Coordinator, Innovation Clubs in her college. She is trained innovation ambassador, mentor of MEITUI Startup Hub, mentor of change in Atal Tinkering Labs, evaluator in Toycathon 2021 as well as in Smart India Hackathon 2022. She received Best Researcher Award from Bestow International and Best Woman Scientist Award from ESN publication. She has published more than 35 research articles in reputed journals and guiding scholars in Anna University Research Center. She is running her own passionate IP from KIM Patents and KM Research Labs. I am very grateful to welcome an eminent person like you, ma'am. Thank you.
Thank you, sister. Now, our respected chief guest will take up his role.
Yes, thank you, sir. Thank you, one and all present over here. And it gives immense pleasure to get connected with you all through this webinar. Thank you, Pugarendan sir, for inviting me. And thank you, the management, principal, and all the coordinators of this session. And happy World Innovation Day to you all, IP Day to you all. So our webinar today is on insights to intellectual property rights, and myself, Indumati, and an intro has been given about me. And I'm passionate about innovations. And because of that passion only, I have started my Kim Patents company as well as Kim Research Lab. And in my college also, I'm making students to be an innovative and intellectual persons. This is what my bio is. And over this session, we will see first what is an innovation, how to be with innovation, how to get an idea, and what are the things with intellectual property rights. This is what we are going to see now. And first we will see what is innovation. Innovation is something what provides solution to the country's challenge. Innovation is not only with the scientific challenges. So whatever we see in our day-to-day life, the what is the problems what we are facing in our day-to-day activities, and what are the problems we are witnessing in our professional life as well as in personal life. If you are finding a solution for that, then finding a solution for that in a new way, then it is considered as innovative, right? So innovation, as we are all professionals and we are all in engineering domain, the innovation should be made to be technical. That's what here we are insisting. So innovation means making things new as well as providing solution to an existing problem in a new way, that is novel way. That is what innovation is. So this innovation is always essential for us to adapt to the culture of innovation, because whatever be in the world, whatever the process going on in the world, if we approach that in a new way, in a new pattern, that it will come under innovation, and it will be accepted by common man, that is every single person in the world, whenever it is easy to adapt and whenever it is cost effective, then only it will be accepted by common man. So if you reach a common man with your innovation, you succeed. That means you succeed in your innovative idea. So whatever innovation you have to do, you have to make that innovation to reach out the common man. That's what the prime motive of innovation throughout the world. And all the innovations reaches to the society if you target with the social challenges. That is why we are having so many schemes in our government for social innovation, social challenges. So that should be termed as social innovative challenges, and so many hackathons are going on. If you see with the hackathons, the problem statements given are all based on social problems only. So if you provide a solution for those problem statements in an novel way, in a new way, then there exists innovation. For that, you have to generate new ideas, and those new ideas has to be validated. And as you are in the engineering domain, you have to approach it in technical manner. That's what needed over here, and this is why we have to go with innovation, right? And if you see over the global innovation index, the global innovation index is taken by WIPO, World Innovation Intellectual Property Organization. So World Intellectual Property Organization, based on the patents, copyrights, and trade secrets, as well as geographical identifications registered over in international, they have given a global innovation index to every country. Our India is in the 40th rank, and it is started from in 2015 we are in the 81st rank, and now we are in the 40th rank. So that much awareness has been reached to each and every person in our country. And over our country, so many patents have been registered, and those all patents have been claimed also. So patent registration means we have to go up to grant. Then once granted, each and everyone who can adopt that innovation has to come up over that. So this is what innovation is. Yes, once again. And now we are in 40th rank, means that much patent we have registered. That's what global innovation is. It is because of the so many schemes introduced by our government towards innovation. And if you see with the innovations present in India, this is purely because of knowledge and outputs. Because over the knowledge and outputs, we are in the 27th rank. Because in our country, we all engineering graduates, whoever it will be, so many Indian jugaads are there, and so many innovations. Those who have not yet reached patent office is there. So many innovations that have not yet reached patent office. If it is reached out to the patent office, then only we will come up with a global innovation index. So some of the scientists only approached with the scientists, and the known innovators only approaches patent office. And based on that, based on knowledge and technical outputs, we are ranked at 27 all over the world. And our market sophistication is at 31st rank. Global innovation index, now we are in 48th rank. And business sophistication is at the 55th rank, because we are all going beyond 9 to 5 timing, but we are not checking up with environmental mindset, and so only we are lagging over there. And human capital and research, we are at the 60th rank, because human capital means here the manpower, whatever. If one has been studied, means they may prefer to go abroad. So human capital is lagging over here. And moreover, research also they are moving up. And institutions means in developed places, there is over the corporations, there is cities, we will be having highly reputed institutions. But in most of the places, we are not, they are deprived of education. So institution we are the 60th rank. And creative outputs 64th rank. That's what I have told in the first line itself. So many inventions have not yet reached to patent office. And infrastructure, really we are lagging with infrastructure, because as we are in developing country, we are lagging with the infrastructure. So these things we have to enhance. You have to enhance with business sophistication. Each and every person have to get a mindset of becoming an entrepreneur. Then only he will come up with new ideas, and innovation may increase. If we give a person with a self-confidence to be independent working environment, or to be an entrepreneur, then this global innovation index, market sophistication, knowledge and tech outputs will automatically increase. And it can be achieved only when human capital and research is present within the country. So if the terms which is below this business sophistication are all increased, then the first three things will increase automatically. And for this, our government have introduced so many schemes. I'm having those at the end of this slide. And for that, we have to come up with a new products. So new product means first we have to know what is a new product. Because if you invent a new product with a new idea, then only you have to go with IP. So how many of you are aware of IP? How many are have invented product? Those things, if we have taken a ratio for that, means we will lag somewhere. So that's the thing here. So innovation means someone will do marginal innovations. Already one product will be there. They will do some marginal increment. That should come under incremental product improvements. So those things will go up to certain margin only. After that, it won't go. So new product means we have classified new products under certain categories. So one is new to the world product. That is, it is perfectly new. No one has invented, no one has discussed, no one has used that. Perfectly new is new to the world products and new product lines. So over a product, one new product with new specifications or a similar product, a Colgate is there, and similarly another toothpaste with a different herbal. If herbal product, herbal toothpaste comes, means it is new product line. Like that new product line and line extensions. There is you over that, if to reach out with the customers, if application has been increased, it means there is line extension. There is fresh. If you see with the pen, a single color pen to the multicolor pen, that is line extension. So one product with multiple applications and repositionings. So if it is used in one place and the same product will be modified to use in the another place, this is repositionings and cost reductions, incremental product improvements. These are all categorized as new product. So you have to give any of the commercial product of new invention with the new invention line. That is if we come up with any of the new product, means they may ask what is the innovative statement for this product. Like that they may ask. So that innovative statement will come up with any of these one category. That should, if you have to climb a product as new product, means you have to come up with any of it. It is perfectly new, means it is new to the world. Like that you can climb. If it is just incremental towards one existing product, means you can tell us incremental product improvement. If you climb your product as a new product with the cost reduction, means you have to come up with this. So like this we are having if you have to come up with industrial applications, means, and if you are with industrial application, if you are giving a new product, means you have to come up with any of these one category to climb it as a new product. Because if you are climbing a new product, then only their your innovation will reach out to the society. And newness means changing the performance capability, changing the application advice, changing the after sales service, changing the promoted image, or changing the availability, or changing the price of the product. So these are all claimed as newness. So new to the there is a new product. So for example, for changing the performance capabilities means a new improved washing detergent. Like that we can take. So here, rather than technical terms, first you have to know what is a new product is. If you know what is a new product, means you can apply the concept over technical things and you can climb for the patent. That's why we are saying with the new products. And the application advice, changing the application advice means using of puzzle ball in washing machines. So we are using powders or gels, and it has been replaced with the puzzle ball. And after sales service means frequency of service of a motor car. Like that we can take. And changing promoted image. So some packages we can see some of the packages. If we see with the detergent itself, means fabric freshener, which is that fabric fresheners of different ingredients has been come with a different colors, right? Comfort, for example, you may take comfort. Red color comfort is pink color comfort, blue, green comforts are there. So those things we can take as promoted image, or change in the promoted image of the product. And change in availability of the product. So availability means based on shape, or vending machines. For different vending machines, different combination of chocolates, different there is a different shape or different ingredients we can use. So changing the price of the product is also come under new product. So this gives you newness of the product. And this newness comes with idea, right? So we have to first find an idea. So what is an idea? Idea means the thing which comes in your mind when seeing a problem. You are witnessing a problem, and for that problem you are proposing a solution, and that solution will be considered as an idea. That idea has to be innovative. There is that idea has to be innovative means you have to you have to bring a new product to the society because of that idea. That's what climbed over here. So find how to find an idea for a problem. That's an important thing. So to find an idea, first you have to check whether the idea what you are proposing is having impact over the problem you have identified. First you have to identify a problem, and for that problem you have to propose one solution. That solution has to be considered as an idea, and that idea has to be with full impact over that problem. So otherwise, if it is not having impact, means it's not having any priority. So if there is no priority, means you have to forget it. And if it is having high impact over the problem what you have identified, means you have to go for it, and you have to plan for it, and you have to plan for a long-term goal. So this is how an idea will be implemented in developing a new product. If you are having a new product, you are having an innovative idea, and that innovative idea can be patented. That's what referred over here. So now we will see what is intellectual property, because to know about intellectual property, you have to know for what purpose we have to go for intellectual property. So as we are all in engineering domain, we have to know first what is an idea, what is problem identification, how to give solution for that, how to make an idea, how to impact that idea, and how to make a product out of that idea, and that product has to be claimed as innovative. So if it is innovative, we have to go for intellectual property. So intellectual property means it should be literary, artistic, or scientific works. So if you are writing a paper, that is if you are explaining a new product in a new technical way, means it can come under literary. Or artistic, if you are giving a new artistic work, means it can also come under intellectual property. That is, whatever the thing come out of your brain will be considered as will be registered as intellectual property, right? That is technical skills. That's why the name intellectual. Intellectual means how you are differently thinking. That's what given over here. So if you are giving any work, any scientific work or literary work or artistic work in a new way, it can come under intellectual property. As like that, performances. So if you are an artist and if you are performing in a different way, means you can claim that as intellectual property through application, through filing in the intellectual property office, IP office. So artists, phonograms, and broadcast can also be considered over here. And inventions in all fields of human endeavor can come under intellectual property. This should be of scientific discoveries. And industrial designs also come under intellectual property. And if you are starting a company, and if you are naming your company, it can come under trademark or service mark or commercial name and designation. And you can have protection against unfair competition also. If anyone is claiming the same work as like you, then you can protect it with unfair competition also. And all other rights resulting from intellectual activity in the industrial, scientific, literary, or artistic fields are all come under intellectual property. This is the definition for intellectual property given by WIPO Convention. In India, we are having intellectual property office, IP office, as in the name IP India. There is intellectual property India. But worldwide, we are having World Intellectual Property Organizations. And if you have to file over for so many treaties are there, so many conventions are there, and based on the conventions and treaties, we can file for international patents. There is no term called international patent. It is PCT patent, PCT application. So first we will see with India, and then we will go with the worldwide, because Indian invention is very much concerned over here, because as it is World Innovation Day celebration only, but we have to concern with our own India first. So the basic principle over here is the contract between creator and sovereign state, that is protection for revelation. So you are inventing a product, you are revealing that product to the world. So whenever you are revealing that product to the world, you are asking your own country to protect your knowledge. So for that, you are making a contract between you, your work, and to that of your country. So it should be claimed anywhere you go. It should be claimed. This is the basic principle. So you are making a contract between you and that of your country. So that's why we are having IP. This is protection for revelation. And the balance between rights of creator and public interest is also to be considered over here for IP. So there is rights and limitations and exceptions. So see, for polio medicine, you all know about polio, right? That polio drops given to children. So when we are all a child, we have also taken polio drops. So this polio drop is not having any patent right. It has been rendered to the society as free of cost. To any country can use the same for composition for polio drops. So that's an exception given to that. And some of the inventions have been limited, which will be taken by government, because if it is having public interest and if it is all come out of government schemes, then it will be rendered to government. So like that, so many things is there with the creator and public interest, because public things won't be taken for patent. So there is a balance between rights of creator and public interest, and these two are the basic principles behind IP. So we have to first make clear of these two, then only we have to proceed with the IP. And over the IP, we are having different types. One is copyright, and another one is industrial property. Copyright is in Tamil we are naming it as Padipurimai, and related rights is there. So copyright is for artistic works or performances and literary works. Those things come under copyright. We will see one by one. And industrial property means under industrial property we are having patents, industrial designs, trademarks, geographical indications, layout designs or topological integrated circuits, trade secrets, and production of new plant varieties. See, over this industrial property, if we have to file for any of the industrial property with our scientific knowledge, we have to come up with industrial application. For that idea, we have to we have to match it with any of the industrial application. It has to come up as a product, either software product or hardware product or any manual product, whatever it is. It has to come up as industrial product with a commercial value. Then only it will be valid, otherwise it is not valid. So if you have to come up with industrial property, means you have to claim any of the industry application with a commercial value. So that has to be noted over here. So copyright we can do for literary works, whatever invention in written format you can give. But for industrial property, if you have to file IP, means that is intellectual property rights. If you have to file, means that application that should may have industrial application with a commercial value within it. That's what needed. And now we will see one by one. First we will see with the copyrights. Before that, the IP laws of India are IP Copyright Act 1957. These all these act with the rules, Copyright Act, all the rules and regulations have been given in IP India website, right? So Copyright Act 1957 given by Ministry of Higher Education, and then Patent Act is given in 1970 by Industrial Policy and Promotion, Ministry of Industrial Policy and Promotion, and Designs Act from 2000. Designs Act 2000 is released in Industrial Policy and Promotion in 2000, and Trademarks Act 1999. Geographical Indications of Goods Act is released with the 1999. It's by Ministry of Industrial Policy and Promotion. And the Semiconductor Integrated Circuits Layout Design Act. So it has been released in 2000, and some amendments have been released with the Designs Act. So because the Designs Act have been given in 1970, it is at the patent only. After the semiconductor and all other things came up, it has been segregated. Some of the designs have been segregated. So we have the Semiconductor Integrated Layout Design Act as a separate thing by Department of IT. There is MIT, you know, right? MIT, Ministry of Electronics and Information Technology, that has been proposed to this. So it has been released in 2000. And in 2001, we had a Protection of Plant Varieties and Farmers' Rights Act. And this is because of, you all know, Nammalwar, right? So a patent right has been claimed for turmeric, an issue has came, and that issue has been cleared with this act only. So this is what Agriculture and Cooperation. This is under the Ministry of Agriculture and Cooperation, and in this only we have protected our plant varieties and Farmers' Right Act. And now copyrights. So copyright means we have original literary, dramatic, musical, and artistic works, and here these are all expressed in material format. So copyright means whatever your idea is, if it is expressed in material form, it can be claimed under copyright. So original literary, dramatic, musical, and artistic works have been claimed. And cinematograph films is also claimed under copyright. Sound recordings also come under copyright. And for copyright, we are having two types: moral rights and economic rights. Moral rights is to protect personality of author, and economic rights is to bring economic benefits. So most of the rights come up with the moral rights because author is having full responsibility of making their literature. Most of the thing are literature only. If you register now in our Indian IP India copyright site, if you register for one copyright, by this time there is now time is 11:40, no? So by 11:40, if you register, if the number is 1190, if you register by 11:45, it will come with 1230. Some 5 to 50 patterns will be registered within 5 minutes. So if you check with the copyright website, so many copyright registrations are going on, and now itself it crossed 10,000 to 12,000. So if you see with the copyright website and if you do copyright registration, you can see how fast, how there is so many persons in our India itself is registering copyright for every 5 minutes. So you can see that, you can visualize. If you register, you can see. So most of the copyrights are come for moral rights only. As I'm running my company, my IP consultancy company, I'm seeing those things day by day, and so many copyright restrictions are going on each and every day. And economic rights, very few economic rights will be there. And over the moral rights, we can claim for right of authorship, right of integrity, and inalienable rights. So right of authorship means the author will get right of integrity, digital manipulation, and no right for display in another. There is another medium. And inalienable rights, no one should just make it in different formats, right, that we can claim. And economic rights is right of reproduction, right of distribution and issuing copies, and those publications, if you go with publications, they may have all these things. Book publication and journal publications, those are all going on. But people nowadays who are all aware of copyrights, they come with moral rights, and then they share with the economic rights. So even if they go for publication, before that itself they come for moral rights. So here right of reproduction means making copies, that is edition of a novel, storage in computer memory, those are all considered within economic rights. And right of distribution and issuing copies, it comes under digital distributions. And nowadays everything is becoming digital, and so it will be considered with the digital distribution, because in IP office itself they need online registration. Over the online registration, we can upload our articles. So then right of communication to the public, for that also we are having rights. So there is public performance and internet communication. If you have claimed this right, means if anyone has to communicate that particular topic to the public, means they have to get consent from the applicant of copyright. Then that is communication to the public should be of public performance or internet communication. Adaptation rights, it is the conversion into another form, that is literary to drama or something. So you have seen so many novels have been turned into movies, right? So abridgment, picturizations, comic formats, and right to make a cinematographic film or sound recording, translation rights, rental rights, resale rights for original artistic works, those are all come under economic rights. And next to that, duration of copyright. So literary, dramatic, musical, artistic works published during the lifetime of author, that is lifetime plus 60 years. The duration for the copyright for artistic works, literary works, dramatic and musical works is lifetime of the author plus 60 years. All other works mentioned in the copyright is 6 years from the date of publication, from the publication itself, not over the grant, from the date of publication itself, 6 years from the date of publication. With the posthumous or anonymous works, works of government and organizations, cinema and sound recordings, photographs are all come under this category itself. So this is what about copyright. And if you come with patent, patent is an exclusive right granted for an invention, which is a product or process. Not only for a product, it should be a process also, but innovative process you have to claim. So process that provides a new way of doing something or offers a new technical solution to a problem. This is what patent is. Patent is always an exclusive right. This is given for inventions which should be of a product or process which claims for new way of doing something with a technical solution, may or may not have technical solution. So most of the case technical solution will only get valid, and so only most of the patents come with the engineering ideas. And a limited monopoly right is also granted by the state to enable an inventor to prohibit another person from manufacturing, using, or selling the patented product, or from using the patented process without permission. So limited monopoly right means if one has filed a patent means they can give rights to another person to manufacture or commercialize that product. So through some licensing, that's what a monopoly is mentioned over here. And the period of patent is for 20 years, but yearly renewal will be there after 3 years. And the conditions for patentability is if you have to claim a patent for a product or process means first thing is novelty, second thing is inventive step, and third one is industrial application. You have to check if you have to come for a patent, you have to check these three. The first thing is novelty. There is invention not known to public prior to claim by inventor. It is very much new to the society. That's what needed. So if you surf or check anywhere, it won't be disclosed. It won't be there. So those are taken as a new idea, and that new idea will only be drafted to claim for patent. So invention not known to public prior to claim by inventor is the novelty. So novelty is the first term for patent, and inventive step. And over that, invention would not be obvious to a person with ordinary skill in the art. It can have new steps. And industrial applications, invention can be made or used in any useful or practical activity as distinct from purely intellectual or aesthetic one. That means just the product or process what you are proposing for patent should be of having industrial application with a commercial value. That is, it can apply for developing a product, or it should be applied for making an industrial process with the commercial usage. That's what given over here. So these three are the conditions of patentability: novelty, inventive step, or industrial application. And over this we are having industrial design also. Design means only the feature of shape, configuration, pattern, ornament, or composition of lines or colors apply to any article, whether in 2-dimension or 3-dimension or in both forms, by any industrial process or means, whether manual, mechanical, or chemical, separate or combined, which in the finished article appeal to or judged solely by the eye. So industrial design means the design should be innovative. So whatever the product you are claiming, already one product already existing in work. So for example, we are having different types of chocolates, but Kinder Joy is different, right? Kinder Joy chocolate. So what is the difference between all chocolates and Kinder Joy chocolate? The design. All chocolates are having the milk and cocoa combination, milk powder and cocoa combination, milk powder, cocoa and sugar combination, and butter is also there. But in Kinder Joy, we are having the package is different, the design is different, and we think that one toy has also been added. So the design is different. So it should be having commercial value, and the design is different, novel to the society, and so it should be claimed as an innovative patent design or industrial design we can claim. So this is what design is. The method of the structure has been changed, the configuration has been changed, or the composition has been changed. Those are all come under designs. Okay, so we are having design patent also. So design means only the feature of shape, configuration, pattern, ornament, or composition of lines or colors. So which should be of 2-dimension or 3-dimension, separate or combined, finished or appealed to, manually prepared or mechanically prepared or chemical processes, but it can have industrial usage. That's what we have to claim, right? We have to say. So industrial usage will be there for that design. Okay, so like that also you can claim for patent. And if you see with the customer products, we are having iron box, different types of iron box. This is one of the iron box, and this is another iron box, steam steam iron box. So both are having inductive heating, but the design is different. This is what industrial design is. And the chappals, we are having different types of chappals, and one particular company is using some logo over the chappal, means that should be come under trademark. And then design, right? Trademark is different, industrial design is different. Design is the shape of the product, color of the product. See, we are having different pouches. This is a pouch, this is a shoulder bag, handbag. So over this the designs are different. And brushes, this one is a brushes, and this also another brush, but it's for different, these two are used for different applications. So these are come under industrial designs. So if you have changed the handle of this, it can be used for different applications, right? So this brush is different, and the painting brush which is coming nowadays to paint the wall is different, right? So like that, so many changes is there. Those are all come under industrial designs. And if you see with the pharmaceutical products also, everything is looking similar, because in pharmacy I have given pharmaceutical product as a separate slide, because in pharmacy only we are having different combinations, and so many patents have been registered from pharmaceutical industrial designs, because different syringe and different tablet combination, that is the color, the coating, the this that wrapper is there, no, the capsules, this capsule color is changing, this capsule size is changing. Those are also come under different designs, industrial designs. So like this, the inventions are going on around the world with even small change over the existing product. Even if the change of the color can also claimed as an industrial design. So we can also do like that. And if you see with the textile and jewelry, we can have different jewelries, different fabric combinations. So these are all also come under design. And next to this, rights of the registered proprietor for the design as well as patent. The proprietor of the registered design has the exclusive right to apply the design to any article in the class in which the design is registered. So whenever you are registering, you have to register for one particular class. That is whether it is coming under ornament, whether it is coming under medical use, whether it is coming under engineering classification, and whether it is coming under there is a sanitary, like that. We have to apply, we have to register for design under certain class. And if you have registered the design under certain class with the IP office, then the proprietor can apply the design wherever he want. He is having the full right. If anyone has to use that particular design, means they have to get license from the proprietor. This is what given over here, and the period of production is 10 years, which can be extended by paying the fee, extension fee for 5 years. And next to that is trademark. So the name of an enterprise or a mark capable of being represented graphically, distinguishing the goods or services of one person from those of other, is considered as trademark. So you all know the logos, right? For Lux soap, the name itself, Lux means it is a soap. Godrej, which is also that is well-renowned name. TVS, Telco, 555, Apple. These are all well-renowned names, and these are all come under trademarks. They are trading under this name. That's why we are calling it as trade name. So this is the name of an enterprise or a mark capable of being represented graphically, distinguishing goods or services. This is trademark. And trade name is also there. Trade name as well as trademark. We can register for trade name as well as trademark. These are all trade names. Lux, Godrej, TVS, Telco, 555, Apple is trade name. For Apple, trade name is this. And you all know trademark, right? What is trademark for Apple? Apple with a bite, with a single bite at the corner, right? This is a logo for Apple. So that logo is considered as trademark, and trade name is Apple. So this is the differentiation, and we can register for both trade name and trademark with a single application itself. And trademark can be sign, words, letters, or numbers, drawings, pictures, emblem, colors or combination of colors, shape of goods, graphic representation or packaging, or any combination of the above said things. So as applied to an article or a product, whatever, as the owner of the enterprise, whatever he fix for his product, and if the same design word is not there worldwide, then he can go for that. And we are having trademark registry. Over that, Indian trademark registry is there, and over that registry we can check whether the trademark is existing or not, whether the trade name is existing or not. If same trade name with the same kind of trade if you are doing, means you can't get this trademark. And whatever you sell, if they file a infringement case on you, you have to give the profit to the trademark registrant who has applied. So if you are starting a company, means you have to go for an ideal trademark and trade name. That's what insisted. And for that, you have to check, if you are starting a business, means you have to check your trademark and trade name in the trademark registry, or otherwise, if you are making an international business, means you can search for that in WIPO, that is International Trademark Registry. And registration of trademark are done by national trademark registries and are valid in that country only. If you have to register, if you have to use that in another country, means then you have to search for the trademark registry over there, and you have to register over there also. And that's why I'm telling, if you are starting a company and if you are going for a trademark registration, means you have to check with worldwide registry, international trademark registry, and there you have to check and you have to name it. Otherwise, you can face problems if you go for international business. And registration is made after examination and publication only. And trademark office is there in our Chennai itself, IP office. And period of registration is for 10 years, but can be renewed indefinitely. Not limitation is there. After 10 years, you can renew it a yearly basis or a 2 years once basis. So 10 years, it can be valid. And the kinds of trademarks are marks on goods, service marks, certification trademarks, collective marks, well-known marks, and trade names. And these are all different types of trademarks. And most of the trademarks comes for marks on good, service marks, certification trademark. Collective marks, most of the well-renowned companies will only use collective marks and well-known marks. And trade names will come up with trade service marks and marks on goods itself. And these are kinds of trademarks. And if you see with the service mark, it includes banking, education, finance, insurance, real estate, entertainment, repairs, trade, transport, conveying news, information, advertising, etc. And if you come up with the certification trademarks, it will be certified by the proprietor as having characteristics like geographical origin, ingredients, quality, like that. For example, Agmark, Woolmark certification mark cannot be used as a trademark, because these are all already, Agmark is a certification, right? Agmark certification has to be given by government, so we can't use that. It won't be used as certification trademark, right? So certifies that the goods on which it is applied for made of 100% wool. So wool mark will be given as it is having 100% wool. It is registered in 140 countries and licensed to the companies, which assure that they will comply with the strict standards set out by the wool mark company and the owner of the mark. So the certification marks will be cannot be used as trademark. They should be owned by the certification organizations only. And a collective mark. Collective mark is a mark that distinguishes goods or services of members of association from marks of other undertakings. So collective marks will be from with the association of persons. It could be manufacturers, producers, suppliers, traders, or other professional bodies like Institute of Chartered Accountants. So Institute of Chartered Accountants is having, if they are having one logo, means they will mark it as a collective mark where all the activities under that Chartered Accountant Institute is coming under this collective mark. So Test Cricketers Association come under collective mark. So there is a group of processes or a group of products come under one mark. Will be there is a similar service or similar goods come under collective mark. So it has to be claimed by that owner, a group of persons otherwise. And well-known marks, we all know Coca-Cola for soft drinks. So we can't claim Coca-Cola in any of the name as it is a well-known mark. And a Toblerone, there is triangular shaped chocolates. It's not available here. And trade names, Godrej for furniture, refrigerators, Storewell, compactor, etc. So seeing this logo itself, we can visualize what is Godrej. If we say Godrej, if you say the word Godrej itself, a flash will come over our mind as this logo. If you say Coca-Cola, this will come flash over our mind. If you say Dairy Milk, Cadbury's is a collective logo where different types of chocolates is there, and which are all coming under there is so many different types of chocolates they are having under Cadbury's name itself. And GE bulbs, its logo. These are all well-known marks, and these are all trade names, right? So the forms of trademark are, it should be of visual, either it will be word or letter or numeral or device, including drawings and symbols or 2D representations of object or a combination of two or more of this. Or color combinations we can take, or 3D sign also we can take as shape of goods or packaging. So we can have trademarks as a visual thing or audio thing or olfactory thing. So visual means it will be of 2D or 3D number, word, letter, like that. Audio means it should be of sound or musical notes. Olfactory means it is smells. Smells also we can make. It's a trademark smell of this. Like that we can register with the trademarks. But you have to represent it in correct manner. It is that's why trademark agents, patent agents are there. So you have to represent, if you are going with a musical note or smell, you have to represent it in wordings to the IP office. So you have to represent it in perfect wording. No one should be missed and no one should be misunderstood. Nothing should be misunderstood. So you have to write like that, right? So these are the forms of trademark. And over the trademark, what should be protected and what will not be protected is, we have the right to use trademarks in relation to goods or services as registered products. If trademark consists of several parts, the protection is for trademark as a whole. And we cannot use state emblems or official hallmarks or emblems of intergovernment organizations. That's what we have to know. So what will be protected, what won't be protected, that's an important thing. And next to this, trademarks is made of any distinctive word, any distinctive letter. It should be of new letter, new word, like that. New form, new name, and a new logo you have to use. Words, colors, numerals, pictures, shapes, colors, logo types, labels, whatever. It should be of distinctive. That's what needed for trademark registration. So see, these are all trademarks. So Yahoo, with the name, with the trade name itself, they are having the logo. Adidas, American Express, BBC. What is this one? Nike and BMW, Burger. These are all. Everything is trademark with its trade name itself. So this is about trademarks. And next to this, geographical indications. And now over the last within last 2 weeks, some 57 geographical indications have been identified and granted, right? Have you seen in the news? Have you seen in the news? 57 geographical indications. 57 geographical indications have been shared, have been granted in India. And one of that is Manapari Murukku. Yes, have seen that in the news. So geographical indication means the one ideal thing. There is one ideal, either goods or services or whatever it is. One ideal thing which is very much known for one particular region is identified, means it is geographical indication, right? So geographical indication is an identification which identifies goods or agricultural goods, natural goods, or manufactured goods as originating or manufactured in the territory of country or a region or locality in the territory where a given quality, reputation, or other characteristics of such goods is essentially attributable to its geographical origin. That is, for example, if you take Darjeeling tea, the taste of Darjeeling tea is very much peculiar. As like Alfonso mango, Kanchipuram silk saree is very much ideal. When comparing to even Kanchipuram is Arani is very much nearer, but Arani silk is different from Kanchipuram silk. So this is what a geographical indication is. The peculiar thing over of a product over one particular region is what geographical indication, right? So last week itself, within this 10 days itself, 57 geographical indications have been identified throughout India and it has been granted. Yes. Is anyone speaking? Yes. Okay. So these are all the examples of geographical indications: Basmati rice, Darjeeling tea, Kanchipuram silk saree, Alfonso mango, Nagpur orange, Kolhapur chapel, and Bikaneri bhujia and Agra pita. And these are all on geographical indications. And next to geographical indications, we have trade secrets. So some inventions, data, information cannot be protected by any of the available means of IPRs. Such information is held confidential as trade secret. If you are starting a company, you will have an ideal procedure within that company, and that can also considered as trade secrets. And you know about KFC, right? KFC, throughout India, we are having now so many KFCs. Even in Chennai itself, we are having so many number of KFCs. So in KFC, they are having one particular ingredients, and they are just showing that some ingredients we are using, like that they are advertising, but they are not revealing that. So that should be considered as a trade secret. But our Indian women have now started cooking KFC chickens in home itself. But they are keeping some secrets, the ingredients, the process, those things they have kept it as a secret, and they have registered it as trade secrets. So many trade secrets are there, and either the process, what going on in management. There is in some of the companies, they are having some management strategy, and that management strategy will be considered as a trade secret for them, and they can register that, like the dressing and chemical formulas. Those are all considered as trade secrets. And trade secret can be an invention, idea, survey method, manufacturing process, experimental result, chemical formula, resin, financial strategy, client database, etc. So whatever, if you are considering, because of this reason, our trade is become blooming. If you are having one thought like that, means you can register it as trade secret in IP office. So this is what trade secret is. Trade secrets are preferred when invention is not patentable. If you are having one process or product and that won't be patentable, means you can go for trade secret with that. So the production is limited only to 20 years, but and when secret can be kept beyond that period, it won't be the protected, because it will well known to the society after that 20 years of period. And the cost of patent protection are prohibitive over this, and it is difficult to reverse engineer. We can come up with trade secrets. And how to got trade secret? It is having restricted number of people having access to that secret information. If you have revealed that to a group of people, means if an enormous number of people, means there is no use of having trade secret. So the trade secrets will be kept with a restricted number of people, and signing confidentiality agreements with the business partners and employees. And in most of the case, if you go for any patent agent or patent facilitator or patent attorney, they may first give non-disclosure agreement to you. Non-disclosure agreement is for confidentiality purpose. So signing confidential agreement with the business partners and employees is very much important to guard trade secrets or patents or whatever it is. Innovative things have to be guarded, right? So we have to go with non-disclosure agreements, and using productive techniques like digital data security tools, and restricting entry into area where trade secret is worked or held. So these things you are witnessing in movies, right? So in most of the movies, we are having this productive techniques. So many productive techniques is there. So some Hindi movies are there showing different new productive techniques, and in foreign English movies also we are having different innovative productive techniques. They are revealing year by year. So you will know what are all the digital data security production techniques. So using thumb, so many things is in using hair. They are having with the genes present with our hair, they are having security. So like that, so many security terms are there. And national legislations provide protection in form of injection and damage if secret information is illegally acquired or used. So there are some rules if that secret has been revealed illegally, and government can take steps for this. So we can go trade secrets too. And production of plant varieties. So registrable varieties and criteria is there. If new variety of plant has been identified, we can register that. So the new variety means we can claim a plant variety as new whenever it is very much new to the society, that is novel, and it is distinctive, different from others. And the next plant variety which is coming out of the first identified plant is having repeatability. That is, it can it can have uniformity and stability. If the next plant which grown out of it is of having different characteristics, we can't climb that, because if there is no existence means we can't climb that, right? So existence is there when it reproduces in the same manner, then only. So that's why we have to check whether uniformity and stability is there. And extant varieties also we can climb. So for distinctiveness, uniformity, and stability. And the persons who can register are breeders, farmers, universities, and agricultural institutes. So you all know we are having one agricultural university at Tanjavur, and national and university NIFTM. NIFTM is there. NIFTM has registered so many plant varieties and so many patents for agricultural products. So if you see with the NIFTM Institute in their website itself, they are having, and they are open for technology transfer also. So they are transferring the technology what they have identified, they have patented that, and they are giving it to commercial persons, that is business persons, to commercialize that idea. And the period of production is for 15 years of annual crops and 18 years for trees and vines. So this is what the production of plant varieties is. And the rights for breeders is in the form of production, sale, marketing, distribution, export, import, like that. However, if the breeder's variety is essentially derived from a farmer's variety, the breeder cannot give any authorization without the consent of the farmer or communities from those varieties the protected variety is derived. So breeder's variety is essentially derived from farmer's variety only. So farmer is having full rights over that, but they are, unfortunately, they are not aware of this. And this is what about IP. So within IP, these are the terms we are having: patent, copyrights, geographical indications, industry design. These things are only present. And if you know about this, is the basic thing behind IP rights. And if you proceed further, it's, if you proceed further means you have to know how to draft for these applications, how to draft the applications. And if you once you drafted the application, you can go for filing. And if you see, for example, if you take a CD player, so the design of the CD player comes with industrial design. This is industrial design, production of the 3D shape used for CD player. And the music played on the CD comes under copyright. And if the CD player, if for example, if we take Sony, Sony means that's the brand name. For that, we can register trademark. And various mechanisms, various materials have been used, and various technology has been adopted for this. This come under patents. So for one single product, we can claim industrial design, trademark. If you commercialize it, you can go for trademark. And for that, you can, if you have any music, or if you have documented the technology used over here, you can go for copyright also. And for the technology used, you can go for new technology have been invented for this means you can go for patent also. So like that, if you have taken each and every product, it may have all these things. And for Apple worldwide, it has been identified as 80,000 patents for Apple phone. And if you see with most of the companies, MNCs, so many patents have been filed every year. And US patents, you search with the Google patents. In Google patents, if you see, US patent is the leading one. And over that, each and every action what we are performing in our system are all patented at the back end. So our India is lagging over that because we are all just users, we are not creators. Most of us are only users only, not creators. We have to get a mindset of creating things. If we create a product, then we can go for we create a product. If we have the mindset of creativity, then we can come up with ideas, and we can climb for novelty. And with that novelty, we can go for patent registration. So this is what needed for IP. And the IP rights should be of patent, which will be for the technology used, trademark, for the business commercial thing. And a geographical indication, if it is intended to one particular region, we can go for geographical indication. And industrial design, based on the design of the product what we are climbing, we can go for industrial design. And for the combination of things what we are using within our product, we can go for trade secret. This is the IP right confined with our day-to-day life what we are witnessing, right? So here for the fan, we can go with the technology with the patent. In our Apple phone, we are having so many technologies which are all patented. And Apple is having its own trademark in its name and its logo. And for the designs, we can go for industrial design. And for geographical indications, I have given here Tirupati Laddu as well as Kolhapuri Chapel. And for trade secret, if you have taken Coca-Cola, the ingredient is very much secret. So it should be taken as a trade secret. And Coca-Cola is for trademark. And the bottle design is for industrial design. And the design is very much innovative, and the ingredient is very much new to the world. And the combinations used are having an innovative process. And so it come up with a patent. This is what I explained over here. And validity for patent, the maximum production is for 20 years. It has to be renewed every year. It comes under the Patents Act 1970, amended in 2005. If you come with a trademark, it will be the maximum production will be lifelong, but renewal has to be done after every 10 years. The Trademark Act, it comes under Trademark Act 1999, amended in 2010. If you come up with a design, it should be the maximum production is for 15 years, and the renewal is after 10 years for next to 5 years. And the Designs Act, it comes under Designs Act 2000 and Designs Amendments Rules 2014. And copyright is having the maximum production of 60 years, and renewal is not required for copyrights. And the Copyright Act, it comes under Copyright Act 1957, amended in 2012. And geographical indications is also for maximum production. The renewal is for after every 10 years we have to renewal it. And it comes under the geographical indications of goods, Registration and Production Act 1999. Patents will cease and be transferred to public domain if patents are not renewed within 6 months of expiry. So every patent has to be renewed every year. Otherwise, it should go to public domain if patents are not renewed within 6 months of expiry of concerned year by paying renewal fee. So every year you have to pay renewal fee if patent has been granted. And if you are having any of the IP rights, you can have license. So license is a permission granted by an IP owner to another person to use the IP on agreed terms and conditions while he continues to retain ownership of the IP. So that's what if you have invented something, and if you have registered for patent or any of the copyright or any of the thing, any of the IP rights, and if you have granted with that application, then you can have license, you can apply for license, and that license can be shared with commercial persons to make of commercial usage, so that you can get the income out of that. So licensing creates an income source. It establishes a legal framework for transfer of technology. So I have told you in NIFTM, they are having so many patents and they are making those patents of industrial usage. So they are sharing their patent, sharing their license for the patents with the commercial persons. That means they are transferring their technology to commercial usage. So it can be done to a wider group of researchers and engineers. And it creates a market presence for the technology or trademark. So whatever you are inventing, you can have a market presence for the invention what you have. So that's what licensing is. So the licensing conditions are: owners of IP prefer to transfer technology through licensing agreements only. All rights or limited rights can be licensed. It can be exclusive or non-exclusive or sold. There is a owner and licensee can use it. And most such agreements provided for royalty payment and non-transfer of it to a third party. So they can sell their IP right. And royalties can be of upfront, part front, and part percentage per condition or sale. Only percentage per production or sale. So most of the products what we are using here, most of the medicines in medical field, it is very much of there, very much of used. That the medicines which are all invented in foreign countries, if we lend them, because for IP rights we have to pay royalty for each and every medicine. We have to pay royalty for them, and it should be of upfront or part percentage per production or sale. If we manufacture the same product within our country, we have to get license from them, and for each and every product we have to, they will fix some value, commercial value, and we have to pay for that. This is what licensing is. That's why we are all insisting in our India we have to make much patents, much innovative terms, and much IP rights, so that we cannot pay to other country. Our money flow will be in our country itself. If anyone has to get, if anyone has to get the technology, means they can pay to our India. That's why we are insisting about this IP. So the particular uses of which the IP can be used are also generally specified. There needs to be careful about the competition law also. So these are the licensing conditions of IPS, and licensing is very much profitable because IBM revenue from patent licensing is $1.7 billion. Texas Instruments generated $3 billion in licensing in 10 years. US and Canadian universities, because through universities so many technologies are coming up. So they have started in the earlier stage itself, but in our India we have started very late, and only the IITs can have these things from the previous days itself. But now only it has been prevailed throughout India into all the institutions through IIC, NISP, like that. So US Canadian universities generated $1.1 billion in royalties by 2001 itself, and New York University has generated $109 million. Ohio University to get $52 million from royalties on the growth hormone drug Somaware. In 5 years itself, they have generated this much. And the CSIR in our India have generated $150 million in milestone payments plus royalty. In CSIR, if you check with the CSIR, under CSIR, we are having so many domains, so many centers, and over that centers, so many patents are also there. And the organizational structure within our India for this is fully under Ministry of Commerce and Industry, with the Department of Industrial Policy and Promotion, and the head is Controller General of Patents, Designs and Trademarks. And over that we are having 4 different offices: Patent and Design Office, Trademark and Registry, Geographical Indications Registry. These are all office, Patent Information Systems. And the Patent and Design Office is present at Kolkata, Delhi, Mumbai and Chennai. In Chennai it is in Guinea only. Next to the Guinea bus stand itself, we are having IP office. And Trademark Registry, Mumbai, Kolkata, Delhi, Chennai and Ahmedabad. Geographical Indication Registry is in Chennai only. An exclusive office is there in Chennai. And Patent Information System has been provided through the institutes present in Nagpur. There is Rajiv Gandhi National Institute for Intellectual Property Management is there. There we can get patent information, and patent training also they are providing. Residential as well as online training they are providing in RGN. And as per the jurisdiction, Mumbai Trademark Registry is present in Maharashtra, Madhya Pradesh and Goa, Ahmedabad. So these are all trademark registries. And as we are all with educational institutions, we don't need about this trademark registry. If needed, we can check. If needed, you can ask, I will tell you. And as from the institutions, to promote these innovations, we are having IIC and NISP, that is Institute Innovation Council, and National Innovation and Startup Policy we are having. Through that, you can invent a product, and that product can be shared, that product can be commercialized or gone through technology transfer through National Innovation and Startup Policy. So that's also why Ministry of Education nowadays this all IICTE, MHRD, everything come under Ministry of Education in our India now. After this NEP 2022, we have everything under Ministry of Education. So under Ministry of Education, we are having this Institute Innovation Cell, and under Institute Innovation Cell, we are having IICTE repository. You all have entered your entries, project entries in the IICTE repository, I think so, because everywhere it is very active. IICTE innovation repository is very much active in all colleges where IEC is there. So over IIC repository, innovation repository, most of the students have registered their projects, inventions, students as well as faculties registered about their thing. And this is from our college. This page is from our college. And over that, you can register your innovative product. This is one of the, this is active now. Up to April 30, you can nominate, you can give your entry, and the best 10 will be nominated to NISP. So you can go up with this. And the main thing is to be with innovation, and to have knowledge about the legal things with innovation when you proceed for commercialization. This is the thing what we have. And for that we are having Make in India also, because whatever innovation you do, you have to render to the society, then only it can get the reach. If you are rendering to the society, prefer India for that. That's how we can lead other nations. So for that we are having a scheme named Made in India, Make in India. So Make in India is very much active. It's having major national initiative. It's having top 25 sectors of economy, and it's a ease of doing business. It enables ease of doing business, and time-based initiatives are also there. And the 25 sectors are ports and shipping, roads and highways, thermal power, textile, government, IT, BPM, pharmaceuticals, renewable energy, automobile components, food processing, electrical machinery, oil and gas, space, defense manufacturing, railways, electronic systems, tourism, chemicals, mining, leather, like that, all 25 sectors, commercial sectors, have come under Make in India. And if you see with the Make in India, the automobile industry and space is a leading one. And ISRO has successfully launched a record of 104 satellites by 2022, and 209 foreign satellites from 20 countries launched by India. It launched 3 navigation satellites for NAVIC, India's own GPS. As well as we have excel in automobile also, because in automobile we are the second largest two-wheeler manufacturer, largest tractor manufacturer globally, fifth largest commercial vehicle manufacturer in the world, and fifth auto cluster in the country. So we are excelling with the innovations over satellite and automobile communications, but we are not sure about the other domains. So we have to enable the IP rights in other sectors too. And if you come up with other sectors, means it should be of service sector, computer hardware and software, telecommunications, trading, construction, automobile industry, construction activities, automobile industry, chemicals, drug, pharmaceuticals, hotel and tourism. And we have to make a look over this, and whoever up for a particular domain can work for innovative idea and commercialize your innovative idea, so that our GDP will increase in future. If GDP increase, global innovation index can also increase. This is what is this is the need of the hour. And so to get knowledge over these things, and how to excel, and how to get ideas, and how to register, and how to invest, how to make India innovative one, you can make use of these links. These are all useful links from our government. So that's about my presentation. If you have any doubts, you can ask. Yes, thank you all. Yes, any questions?
No, no.
Yes, sir. Yes, sir. Yes, any questions?
No, ma'am.
Sir, not audible. If any questions, you can ask. Yes, sir.
Ma'am, it was a good presentation. Ma'am, regarding the technology readiness level, how can we support our students to submit their projects above TRL 7 to 9?
So if they have developed the product, because if you see with the technology readiness level greater than 6, you can have the product be ready for commercialization. It has to finish the manufacturing readiness level also. So if you see with the technology readiness level 6 and 7, whatever the project you have proposed, you have just developed the project. You can have finished the product. It will be of in the final stage. That is, you can have prototype in your hand. That's needed to be with the TRL 6 or 7. And 8 means it has been commercialized already. And if it is in TRL 6 or 7, it is better to have IP right for the product.
So if it is 8, it has to be commercialized.
It has to be commercialized. Then only it can come on with 8.
Yes, ma'am. Okay. Thank you.
Yes, ma'am. Yes, any other questions?
No.
Yes, any other questions? Sir?
Devamani, sir.
Ma'am, sorry, ma'am.
Sir, if there are questions from the student side, they can ask, sir.
Yes, any questions? And if you have any questions, you can ask me anytime.
No questions, madam.
Okay, sir.
Shall we go for what of them?
Yes, sir.
Raise your standard and the universe will meet you there. Thank you, ma'am, for your valuable work, and it really makes us so proactive. Gratitude is the utmost virtue to define you as a loyal one. Now I call upon R. Janani to propose the vote of thanks.
Words in English, but nothing better than the word thank you. I would like to extend my gratitude to Dr. G. Balaji sir, Head of AAA Department. Our special thanks to the Chief Guest, Dr. K. Indumati, who has shared her valuable time with us. Finally, I would like to thank our faculty members and students. Thank you all.
Thank you.
Madam, thanks for your spending valuable time.
Thank you, ma'am.
Yes, sir. Thank you, sir.
Ma'am, kindly take one group photo.
Yes, sir.
Ma'am,
Yes, sir.
our group photo.
Okay, sir.
Dear students, switch on your videos.
Sir, you are not audible, sir.
Thank you, ma'am.
Sir, thank you, sir. Shall I leave, sir?
Thank you so much, ma'am.
Okay, sir. Thank you. Thank you very much. You have given the
Yes, ma'am.
opportunity.